2020 for a second term of office. Professor Skelton, welcome to our conference this morning. And we're going to look forward to hearing from you now on South Africa's child justice law reform journey.
Thank you very much, David, for that introduction. And greetings to everyone. It's wonderful to be part of this conference with you. Although we're all online, I am actually in Glasgow. I am, as you know, a visiting professor at the University of Strathclyde. I'm being hosted by the Institute for Inspiring Children's Futures, and I'm very grateful for them for inviting me to Scotland, and very grateful to the organisers of this conference for inviting me to do this address today. So I've been asked to talk about South Africa's law reform journey for child justice. And I think that that's a journey is always a very good analogy for the processes that we go through in trying to improve systems. And I think you yourselves are on a journey. We in South Africa are also on a journey. Of course, that journey doesn't really ever end, but we have got a story to tell about what has happened in South Africa since South Africa became a democracy in 1994. That backdrop is very important, of course, and I'm going to speak about that in a few minutes. But just before I do so, let me tell you that what I'm going to be talking about are two pathways of law reform, ways that the law can be an instrument for change. One of those is through the standard law reform process, legislation, the development of legislation. And the other is through the courts, how litigation can also be a powerful instrument for change and for transformation. So let me begin then with that first leg of law reform. And the backdrop that I mentioned earlier was the fact that, of course, in South Africa, we had come from a history of apartheid in which the majority of Black people were relegated to second-class citizens. They had very few rights. They could not vote. And the attention to the criminal justice system during the apartheid years, which lasted from 1948 to 1994, really was not focused on doing anything very positive. It was a justice-oriented, harsh criminal justice system. It did have some features that recognized that children are different, in that, for example, court cases involving children were always held behind closed doors, and the idea that youth should be a mitigating factor in sentencing was there all the way through. And I think that one could say that there were some features that recognized the vulnerability of children and the importance of seeing their connection with the criminal justice as an opportunity to assist them to change. But there was no system set up to do that. So there wasn't a separate self-standing child justice or youth justice system. And so when the first opportunity for change came, which was in the early 1990s, when Nelson Mandela was released from prison in 1990, and there was a period during which the ANC, the African National Congress, was preparing for their transition into power. And that was a very exciting time, as well as the first few years of being in power, very exciting time where there was a lot of opportunity for change. And with such opportunities, come pathways, windows of opportunities to change things. So we knew what was broken at the time. Those of us who were working on the ground, working in the courts, we knew what the problems were in the system. But under the old regime, there just wouldn't have been a possibility of big change. Now, suddenly, there was an opportunity for substantial change. And of course, we started immediately thinking about what kind of system would we want to see in South Africa? When Nelson Mandela became the president, the first Minister of Justice, Dalla Omar, decided that he would set up a committee at the Law Reform Commission to investigate this possibility of a new system for children in conflict with the law. And I was actually appointed to chair that committee. I was quite young at the time. I was 34 when I was appointed to chair that committee. And it was an incredibly exciting phase where we were able to really think about, I mean, the title of my talk today is Reforming, but we were always using the word transforming at the time. And sometimes I think we were actually creating, because there was not much there. So we were able to, with a rather clean slate, start this law reform process. So what we did was we began to do our research, and of course we looked at comparative models. And I'm sure you'll be pleased to know that we only looked at 3 country models, and one of them was Scotland. The other 2 were New Zealand and Uganda. And I think in the end, one can see that we did take a little bit from all of those. So what we noted particularly about the Scottish system, of course, was the hearing system and the level of specialization. We noted, because we were very aware of the debates about the continuum from a welfare system to a more justice-oriented system, and where we would position ourselves along that continuum. In fact, our system at the time, you know, that the way children had always been dealt with was through a very justice-oriented system. So we were interested in how to make pathways with the welfarist system, but we didn't feel that we could opt for a completely welfarist system. We were also very interested in the restorative justice framing that we saw in the New Zealand system, but also in the Uganda system, where it was linked to African traditional systems. And this was of great interest to us. And what we found at the time was when we talked about restorative justice, it was very easy for us to put that across to a South African audience, because it was so reminiscent of indigenous justice systems that it struck a positive chord very often with our audiences when we were trying to talk about what sort of system we were thinking about. And the restorative justice features did definitely become quite important aspects of the future child justice system that was born as a result of this process. Another really important international influence on our law reform process was international law, in particular, the Convention on the Rights of the Child. So around about the same time, South Africa ratified the convention in 1995. And we have a dualist system, which means that by ratifying, we didn't automatically incorporate. So like Scotland, we would have to find a way to incorporate the convention into our law. We didn't go the wholesale incorporation route that Scotland is going, as excellent as that process is. But it wasn't really necessary for us because of the way that our constitution recognizes international law. The South African constitution says that when considering a right in the Bill of Rights, the courts must consider international law and must prefer an interpretation that is in line with international law. That actually then means that international law becomes automatically incorporated through the judgments that we get from the courts. And that has been seen to happen. So in the second pathway, when I start talking about litigation, I'm going to come back to that theme and pick up on it again. But going back to the law reform, the legislative reform journey, after having had a look at all of these different systems and keeping that framing of the international law in mind as well, we came up with a system that I would say is largely a justice model, but it is very restorative justice oriented. We do have a heavy emphasis on diversion. We have family group conferencing as a diversion, but it can also be incorporated in as a sentence. What came from the Scottish system was something that we call the preliminary inquiry. And this didn't exist in our system before at all. But the idea was that as soon as the child comes into contact with the system, they are assessed right at the beginning by a probation officer who in our system is a social worker that falls under the Department of Social Development. And then there is a preliminary inquiry that is presided over by a magistrate. But at that inquiry is the probation officer, the child and the child's parents, and if they are legally represented at that point, the legal representative sits in as well. And the purpose of this preliminary inquiry is to really try to decide how the case will go forward, if possible, diversion. We also have actually, prior to a preliminary inquiry, prosecutorial discretion to divert. So some cases bypass and get diverted out right at the front end of the system. But the more complicated, more serious cases all have to go through a preliminary inquiry. And there's really the idea of the preliminary inquiry is to try to make sure that the presiding officer and everybody working on this case understands what are we really dealing with here, and not simply coding cases on the basis of what kind of an offense, but rather looking holistically at the child within the family, the resources around that child, and what supports and what referrals would optimally be made. If the child has, is not acknowledging responsibility, or if the case is considered too serious to be diverted, then the case proceeds to a trial in the Child Justice Court, or plea and trial in the Child Justice Court. But diversion remains an option all the way through. The Child Justice Court is also still a specialized court with specialized rules. So as you can hear, our system is a bit of a hybrid of some of these different things we learned from looking at different systems. When the bill first went to Parliament, it entered some stormy waters. So to continue on our journey analogy, this was a bit of a rocky part of the pathway. By this time, I think, at that time, actually in the 1990s, by this time we were in the 2000s, there was quite a strong law and order backlash that was partly caused because South Africa does have a very serious crime situation. And we had quite a difficult time getting the bill through Parliament intact and trying to communicate this idea that it was really important to treat children differently and to see their brush with the law, the first one particularly, as an opportunity for change, and to actually make sure that this child wasn't harmed by the process, but helped, to go on that other pathway of proceeding to an adulthood that would be free of crime, which would clearly benefit society if we could achieve that. I think in the end, the bill managed to make it through with most of its features intact. Some changes that I felt were not good happened along the way, some toughening up, you could say, of some of the provisions, resulting in some possibly quite lengthy sentences. The sentencing focus is still non-custodial, and we have managed to reduce our number of children in any form of custodial sentencing quite dramatically over, certainly the last 15 years. We've done very well in getting those numbers down. However, I think we do still have a few, we have about 100 children actually in prisons. They would all be over the age of 14, most of them are 16 or 17. And we have several hundred children in secure care institutions as well. So we'd managed to do quite a good job, as I say, by working together across different government departments to make sure that deprivation of liberty was used as a measure of last resort. But when I first started working in the system, many children ended up being deprived of their liberty. So I can see huge advantages and change over the years that I've been working in South Africa on that aspect. But what's quite interesting is we've now had a 7-year review of our Child Justice Act. The Act came into operation in 2010, and it was reviewed 7 years later. And what has actually happened is that the numbers of children have dropped dramatically across the system as a whole. And I want to actually show you a slide that illustrates this. It's really so interesting. Let me start. So this, let me just see. Are you able to see that slide? Can someone just say yes for me or give me a thumbs up or something?
Yes, thanks, Anne. I'm seeing it very clearly. I hope everyone else.
Good. So let me explain it. On the left-hand slide, we can see all the numbers of children in prison, sorry, not prison, this is the entire system, children coming into the child justice system from 2010 when the Act came into operation, the Child Justice Act, through to 2018, and this pattern continues into the following years as well. So quite a significant drop in the number of cases. What's really interesting is, I'm just going to switch back to another slide, or I can actually just tell you to look at the one on the right maybe, is that if we plot this against an international trend, it's really interesting to see what we see. So you can see the different colors there. The UK is the blue, USA is the red, New Zealand is the green, Canada is the purple, and Germany is the sort of pale blue one. And the square or oblong is just matching the 2010 to 2015. And if you look at that trajectory and compare it with the South African trajectory, it's looking very similar. So it's really interesting to contemplate what's causing this drop across the system. In South Africa, we can say, well, obviously we introduced a new law that caused a drop in numbers, but a year-on-year drop in numbers, even after a few years of the Act coming into operation, is more difficult to understand the reasons for that. And we aren't exactly sure. One issue that we think has occurred in our system is that police working with the new law are somewhat, they're used to the standard criminal justice response, which is, you arrest someone, you detain them for a period of time till they come to court, and then they are considered, or they could be bailed from the police station. But anything that's different from that seems to cause some confusion. So our Act says that children must not be arrested. They should be warned to appear, and they can actually be detained in that first phase under certain narrow circumstances. But I think that has caused our police to kind of avoid taking children into the system. So what's happening is we're getting a kind of informal diversion by police at the front that's not really part of the system, which wasn't our intention. The jury is still out. We don't have a jury in South Africa, but I mean, the figurative jury is still out on what is whether that's good or bad. I mean, having less children in the criminal justice system seems to be a good thing. But on the other hand, if you see the criminal justice system, the child justice system, as an opportunity to see that something is going wrong and to refer children to the right services, and they don't get a criminal record, then it may be a little worrying that so many cases are being referred away and we're not getting to see them, and there's no kind of interaction happening on that. So I think I'm going to just stop sharing this slide now and come back to the full screen. So it's been interesting for us to look at that and also to see that it is in keeping with international trends, although South Africa is quite different from a lot of those other countries, but we see some similarities across the world that we don't have all the answers as to why that's happening. So that kind of brings us to the end of that first pathway, and I'm now moving on to the second pathway to talk about litigation. I've already mentioned that our Constitution, we have a Bill of Rights, and in that Bill of Rights, we have a very strong section on children's rights. And of course, all rights in the Constitution are available to children as well, except those where they're clearly excluded. And we have been able to use this legal framework of our Constitution within the broader international law framing of the Convention on the Rights of the Child to get some really good judgments where we saw that there were problems in the system. So this was happening parallel to the law reform process. Whilst we were working on the law reform, we were also looking at what could we do to change the law through other avenues. The very first case that came to the courts wasn't really that strategic. It was referred by a magistrate. You'll be horrified to hear that in 1994-95, we still had whipping or caning as a sentence for child offenders in South Africa. And the magistrate had sentenced a group of children to corporal punishment, but he didn't have it carried out. He then referred his case to the Constitutional Court to say, is this still a constitutionally compliant sentence? And the Constitutional Court, using international law and comparative law, made a very firm finding that that was actually a violation because it was cruel, inhuman, and degrading treatment, and therefore corporal punishment as a sentence stopped immediately in South Africa. That was really just the first year after the Constitution came into operation. So it was the very first case, and it had a successful outcome. So that actually then was quite interesting for those of us interested in litigation. We're thinking, okay, well, what other cases could we look at? What could we bring? And soon we got our inspiration because the government passed a new law, or you could say Parliament passed a new law, which introduced minimum sentences. You know, these kind of minimum sentences where you say, for this kind of offense, there's a minimum sentence of 10 years imprisonment, and on the second offense, it's 20 years imprisonment and so on. It was primarily for adults, but it included 16 and 17-year-olds into that system of minimum sentences. Now, under our Constitution, children are below the age of 18. And the Child Justice Bill, but it was at that time was still a bill, did see children as under the age of 18. So everyone under the age of 18 is included in the child justice system. But this law tucked 16 and 17-year-olds in to the minimum sentences law. And the minimum sentences law was not, how can I put it? It wasn't mandatory in the sense that a court could depart from the minimum sentence, but it had to work backwards. So the minimum sentence was what they should do, but if they could find substantial and compelling circumstances, they could work backwards. So the Ministry of Justice tried to defend this legislation that the Centre for Child Law, where I was working at the time, we attacked that law. We said that law is unconstitutional because our Constitution says that children may not be detained except as a measure of last resort and for the shortest appropriate period of time. And that this law turns that on its head. It says that children must be sentenced as a first resort for the longest period of time. And yes, you can depart from that as a sentencing judge, but that still inverts the process. The minister tried to defend the law on the basis that there was discretion, but in fact, we were successful and the Centre for Child Law won that case. I will be putting the references up into the chat. When I finish speaking, I'll put them there for anyone who's interested in looking at the case. So that was an important case, and it relied on our Constitution, but also on the Convention on the Rights of the Child, Article 37B, which was actually the basis of our own constitutional provision as well. And it also made the point that 16 and 17-year-olds are part of the child justice system, and that you cannot arbitrarily just tuck them into the adult system like that. The second case that is a good one to illustrate how international law can be important was about arrest. It dealt with a 15-year-old girl. Her name was Michelle Raduva. And Michelle got caught up in a neighbor dispute between her mother and the neighbor. And because she tried to stop the police from arresting her mother, she was arrested for interfering with an officer in the course of his duties. She was held for 17 hours at the police station. She was first of all bundled into a police van, held at the police station, and she was ultimately released and not charged. However, she had been deprived of her liberty, and so she challenged that and she sued the Minister of Police. We entered this case in the Constitutional Court. She lost her first 2 rounds, and when she got to the Constitutional Court, the Centre for Child Law entered as a friend of the court, an amicus curiae, to make arguments linking this to international law and our Constitution. And we relied on the idea that deprivation of liberty starts from the moment of arrest, and that it was very important to look at deprivation of liberty from then. So it was interesting development from the first case, which had looked at deprivation of liberty at sentencing. This one was looking at deprivation of liberty right from the beginning of contact with the criminal justice system. And we got a very nice judgment there from the court, which, talked about the importance of treating children very differently, and also locating that within our own history as a country, where there'd been a lot of police brutality and detention of children in their struggles against apartheid, for example. This all comes through nicely in the judgment, and I think it's a great judgment as well to read. The third judgment that I want to tell you about is one called Jay versus the National Director of Public Prosecutions. Jay was a 14-year-old boy who was charged with sexual offences, a number of sexual offences, and his particulars would, because he was convicted of sexual offences, automatically go on the National Register for Sex Offenders. And the judge that dealt with the case on review said that he wasn't comfortable whether this was in line with the Constitution. So he invited amici curiae, and again, the Centre for Child Law, we went in and argued that when it comes to child offenders who commit sexual offences, they should be treated very differently from adult sex offenders, and that they should not automatically be placed on the register. Rather, the default should be that they do not go on the register unless there are very special circumstances where the prosecution can show that there is a real risk of reoffending and certain circumstances surrounding the offence that would warrant it. And so that case too had quite a big impact on the way that child offenders are dealt with in the criminal justice system. So, as I've said, the journey is ongoing. I've recently been involved in a project which is a follow-up to the global study on children deprived of their liberty, where we've been visiting secure care centres and looking at a model for oversight in secure care. And I'm sorry to say that we've picked up some very worrying practices in these secure care centres, such as strip searching and the use of isolation. So there's still work to be done. Don't get me wrong, I don't think that what we're doing in South Africa is great. I think we've got a lot of work still to do. And that's the point, isn't it? That we all have such a lot of work to do, and we need to continue on our journey of law reform. And I wish you well. I think you are at a very interesting juncture. You're at a crossroads in your journey. The incorporation of the Convention on the Rights of the Child, I believe, creates a lot of new opportunities for Scotland, and you can imagine how in both of these pathways that I've described, as well as, of course, in improving practice, the Convention on the Rights of the Child can be such an important guiding instrument in your work going forward. Thank you for giving me this opportunity to talk to you.
And thank you so much for that fascinating talk. To me personally, so much of what you said is absolutely music to my ears. It is a reminder to us here in Scotland that however excited we might feel about the progress we're making, or we feel we're making, in some senses, I think we might just be catching up in certain areas. When I hear some of the developments that have taken place in South Africa over the last few years. I should also feel a little bit ashamed. My fascination in restorative justice was triggered by a visit to New Zealand, but I was unaware of the development of that principle in Uganda, which was the country of my birth. So I'm going to follow up on that. Now, we do have time for a few questions if you're happy to take some of them. There's a number of questions have come up on the chat.
One of the questions here, David, as well.
Yeah.
I can see one of the questions, David, is about how South Africa deals with children under the age of criminal responsibility. Can I deal with that one? I actually had meant to talk about that. I know that that's an important issue for Scotland. Yes, so we had, like Scotland, a very low minimum age of criminal responsibility. It was 7. We had inherited the English method, although we have Roman Dutch law in South Africa, we had inherited the English doli in capax, doli capax presumptions. These were old Roman law ideas, I think, that said the divided childhood into categories. Below the age of 7, there was no presumption that children completely lacked criminal responsibility. And between 7 and 14 in South Africa, we had a presumption that children lacked criminal responsibility, but that it could be proven. And if it was proven beyond a reasonable doubt that the child had criminal responsibility, then that child could be tried. But that still leaves you with a very low age of criminal responsibility at the age of 7. So when we first brought the bill to court, we had aimed to get it up to 12, from 7 up to 12. And that was where, you know, back in the late 1990s, we were aiming to do that. And we relied on the Convention on the Rights of the Child. And at that time, General Comment number 10 on juvenile justice had just been published. And it said that the age of criminal responsibility should be 12. So we were using that with Parliament to try and persuade them. And we got pretty close to persuading them, but they were worried, and they said, well, we don't know how many children we're talking about, and we don't know exactly what crimes they commit, and so on. So what we did in the end was we built in a clause in our Child Justice Act that said that the age would be raised from 7 to 10, but that in 5 years after the Act coming into operation, we would reconsider that and take it up to 12. And I know that when Scotland was debating all of this, I actually was invited to address the Scottish Parliament as a member of the Committee on the Rights of the Child that time, to talk about General Comment 24 and why the committee was now saying 14 instead of 12, and whether or not Scotland shouldn't just go all the way right up to 14. So I did try and make the case for that, with Bruce Adamson spurring me on and telling me, you know, this is really important, this is an opportunity, we've got to try and persuade the government now. And I tried my best, but I also told them in that address about that South African clause, that you can put it into the law to say we'll review this in a few years' time. And I'm pleased to tell you that in South Africa, we have managed to raise the minimum age now from 10 up to 12. So we're at 12, but again, we put it back into the law again that it will be reviewed again in 5 years' time. So it's a kind of incremental process that we're going through, try and get to 14. But between 12 and 14, we still assess criminal responsibility. So the presumption of a lack of criminal responsibility below 14 is still there.
Thank you. Beth Ann, have you identified a question. There's one that I noticed in the chat, that we're going through the process here of in the consultation on the new care and justice, the Child Care and Justice Bill, of considering bringing 16 and 17-year-olds into our children's hearing system and to treat 16 and 17-year-olds as children. But the question highlights the existence of some resistance to that notion in certain quarters in Scotland. And I think the question really is, if we don't bring 16 and 17-year-olds into our childcare system, our child justice system, in the children's hearing system, would that amount to a breach of the United Nations Convention on the Rights of the Child? Are there rights issues here that Scotland should be alive to?
I would say that there could well be an argument that not including 16 and 17-year-olds into the youth justice system would be seen as a breach of the Convention on the Rights of the Child. I do understand the difficulties in the debates, and often this is about, I think those debates are more about sentencing, though the public often just blurs it all together. So I think most people would agree that when it comes to understanding that children and young people are different from adults, that their brains are still in development, that they are still very open to influence, they tend to go with the peer group and so on. All of that is pretty well understood, and most judges certainly understand it, but even most members of the public do, because, right, we were all teenagers once. We all remember what that feels like, that sense of daring, that sense of wanting to break the rules and so on, and not thinking through all the consequences properly, which changes over time. So I think there would be a lot of scope to get public support for including children in the criminal justice, in your youth justice system, all the way up to 18. And maybe even try and fudge those lines at the upper age limit a little as well. But maybe what one can do in order to satisfy some of the issues is to see how does that calibrate with sentencing. I know in Europe there are a number of countries that kind of keep the possibility of heavier sentences for 16 and 17-year-olds who are charged with very serious crimes. But if you do that, don't talk about that as referring them to adult sentencing or treating them as adults. You're still treating them as children and young people, but recognizing that sometimes the severity of the crime and the circumstances surrounding this and the number of offences previously committed all factor into sometimes the requirement as an exceptional measure of a lengthier sentence than might be done for the average. I hope I'm explaining myself with all the due caution that is required for these kinds of threshold discussions. But I think it's better to bring the children into the system and think about what it is that worries the public and see if you can find a child rights compliant way of dealing with those concerns.
As well, that leads very nicely to one of the other points that's been raised. I think sometimes we perhaps don't give enough consideration to the discretion that's exercised by prosecutors. Whatever the law might say about the minimum age of criminal responsibility, considerable discretion is exercised by prosecutors as to how to deal with that. And in Scotland, that's going to come very much more into focus when decisions are made by prosecutors about whether a child or a young person should go to the children's hearing or to the criminal court, because our age of criminal responsibility is still 12, and so any child of 12 or over can still be prosecuted in the criminal court, so that there is a decision to be made about how the cases are to be divided. And it leads to that question that came up in the chat, and that you've touched on a bit in your last answer, Anne, about how we deal with serious young offenders, offences of murder, rape, and so forth. Does that really become an issue of how we address the sentencing, or is there more to it than that?
My thinking is that when it comes to understanding the criminal justice processes and understanding, it's still a capacity question in a way, that we know that young people, even though we accept that they are treated as having criminal capacity once they're over 12, but we also say that between 12 and, I would argue, it should be 18. Of course, any bright lines don't really make sense, but we have to have bright lines, otherwise we can't work properly. But let's say 18 is that upper limit. There is an understanding that they need to be treated differently from adults. And that is very important, I think, in the whole system, in the approach. And I think that discretion can be very important in there. But what I would guard against is ever saying that someone under 18 should be dealt with as an adult. They shouldn't be dealt with as adults, ever. They should be dealt with as children. Yeah. Does society's expectation that certain crimes must attract, heavier sentences? Does society's true need for protection and safety sometimes require a tougher sentence? Yes, that can be so. But to me, that doesn't mean you deal with that child outside the child justice or youth justice system. It means that you have a way of dealing with that, a safety valve that allows for that. But nevertheless, in the hearing, I would say, you shouldn't be treating 16 and 17-year-olds that differently from 14 and 15-year-olds. And where I think the public pressure tends to come is in sentencing. And that, I think, is what we'd have to deal with. Of course, there is a numbers element to this, because we also know that with each year, the numbers get bigger and bigger. So 16 and 17-year-olds, adding those into your hearing system will probably put quite a considerable burden on your hearing system because of the numbers. So that's something that logistically you would have to prepare for very well. But certainly, I think I would say that incorporating the Convention on the Rights of the Child requires you to do some very careful thinking about how to bring this system for the 16 and 17-year-olds in line with the Convention.
Thank you. To change the subject, we are a bit ahead of schedule, and one question has come up is whether you could expand a little on South Africa's reason for not going down a purely welfare route in relation to children. I found it quite interesting in New Zealand in 2011 when I was there, that having embarked on a welfare approach in the early 2000s or the end of the 90s, New Zealand was turning more towards what they called an accountability, model of holding children and young people more to account for their behavior, especially if it was offending behavior. And I wonder if you're able to expand on that, what the thinking was in South Africa around that.
Yes. I mean, it's set against the, a context of the last 120 years or so, from when we started to see child justice systems or juvenile justice systems developing. And we know that the original ones were quite welfarist in their approach. So the ones from America, the American model was quite welfarist, and then the early English models and continental models were quite welfarist. And then over the years, it seems like there was a switch over to more justice-oriented models, due process, so the famous case of In re Galt in America that shifted America away from a welfarist system to a more kind of just desserts or justice-oriented model. And I think a lot of this is about what the kind of what public acceptance you can get. So obviously for you, the Kilbrandon report made that huge inroad by getting people to think more holistically and more long-term than usually is done. In other words, I think the Kilbrandon report said, this is what will be best for children, let's do it this way. And that, in a way, was a bit reminiscent of those early reformers who did the same thing. Most of the time, law reform has to be done within a live situation of political expediency. And that often means that the call for tougher sanctions, tougher laws, is always somewhere there in the background. And that's what happened to us in South Africa. But I think restorative justice gave us the middle ground that we were looking for. And basically restorative justice is, as you mentioned, David, it is an accountability one. So it says children will be held responsible for their offenses, but they can be held responsible in a more restorative way rather than in a totally justice-oriented model. But that it's based on the idea, I think, that it's important to acknowledge how your actions have an impact on other people, because that's how children and young people grow up to become, responsible adults that will live well in society with others. So it's kind of an important part of a human's development, actually, to be responsible. But we don't want to throw the book at children. We want to understand that they make mistakes and that they need to be assisted and need to be supported. So that for me is, I think, what happened in South Africa. We found that restorative justice was a more understandable route for our population than a welfarist route, because it was still a way of holding children responsible. But I mean, I'm not saying that the entire system is restorative, because some of it is a trial. So some of it is not that restorative. But again, it's sentencing. We can incorporate restorative justice processes at the sentencing stage. So there is that possibility to bring that in there as well. So it's a hybrid system that we have in South Africa. I don't think there would have been very much public support for a welfarist model. But there was a lot of support for a restorative model.
Thank you so much. Beth Ann, I don't know if there's any other questions you've identified from the chat that Anne might be asked to address.
Yep, I've got a couple, David.
Yeah.
Brilliant. I'd like to say thank you to Anne as well for your input this morning. And I think initially, my first initial thought as well, when you were talking about secure care and some of the issues that you're experiencing there, we're over 18 months now into our journey of our secure care pathways and standards, and it's about educating people and getting them to implement them now, but we are still experiencing some of the issues that you're facing as well, which I thought was really poignant, just to note. So one of the questions I've got is, what do you think, Anne, are the main reasons that have contributed to the reduction in the young offenders numbers that Scotland could learn from to remove the 12 children that the Scottish Government are committed to removing?
Well, it's difficult to make the case that our shift to the new system caused that drop in numbers, because it's a much better system that treats children differently. The South African government does make that claim. I'm not completely convinced that one can put it down to that. There may have been other factors at play. So an interesting factor for us was that during the same years, we introduced a cash grant to families, which helped families support children, families living in absolute poverty. And the cash grant, a sum of money, like a benefit that's paid every month, also covers the same period and was gradually increased over that period. So, I mean, one argument might be that families were more capable and more cohesive as a result of this cash grant. And that might be one of the reasons why we see less children in the criminal justice system. We don't know. Another reason advanced internationally for why this has happened internationally is children's socializing behaviors having changed so much because of a shift to online play, online interaction, which might have taken children out of situations where they used to commit offenses. It may have introduced some new offenses that weren't there before, of course, as we know. But these are all speculations. What I do think is quite important is to keep very good data, and I'm sure you would do this as you go, so that you can really, really pick up on the details and the reasons for change. Because I saw one question in the chat there now about recidivism. that 7-year review hasn't been able to assess recidivism, partly because we don't have enough individualized data. And we're not able to sort of track individual children well enough to be able to see that. So the more you can do of that, and then of course, use your data. That's another thing. A lot of governments capture information, but then they don't analyze it and feed that learning back into their systems very well. So certainly that is something that if you can try and think about doing that and building that in from the outset and saying to yourself that whatever changes you make, they're always open to review. And you know, the learning of trying them out can also help to improve them over time.
Before you put your next question, Beth Ann, can I just make a comment? I may be the only person who can really say this in this gathering, but we should not underestimate the importance of educating and informing decision makers, prosecutors, and especially judges in understanding the impact of criminal law on young people and how they get involved. Mm-hmm. I'll say no more than that, otherwise I'll get into trouble.
Don't we go on rogue on us now, David? Mm-hmm. So thanks, Anne. The next question that I've got is, in Scotland, we see a reluctance to regard 16 and 17-year-olds as children, and the Children's Care and Justice Bill is at risk of maintaining this situation. So do you think that this would be a breach of the UNCRC if it did, and what advice would you give to the community in order for us to challenge this?
I do think it will be a breach. Let me give you an African example that can show that it could be. As you may know, there is also an African charter on the rights and welfare of the child that is a full-length charter. It's the only other full-length children's rights instrument. And a case was brought to the African Committee against Malawi because Malawi had in their constitution, they had a provision that said that children up to the age of 16 would be dealt with as children in the criminal justice system. The African Committee entered into discussions with the Malawian government, and the Malawian government changed their constitution to bring it in line with the African Charter on the rights and welfare of the child, and on the very same issue that you're asking me about, 16 and 17-year-olds being included in the criminal justice system. So there is a nice learning that Scotland can take from the African system and Malawi. I saw another question, Beth Ann, that was about whether it said, obviously for restorative justice acceptance, there was a cultural appropriateness or comfortableness with it in South Africa, and that might not be here in Scotland. That could be true, but what I see in the literature in restorative justice is that there is often, in order to try to help people understand it, there's often a connection with older ways of doing justice. If we go back to, before Rex versus so-and-so, we see that people actually resolve their disputes in a different way without the state or the king or the queen being so heavily involved. And so so at that stage, people resolve their disputes through sitting around in circles and debating issues and coming to solutions and paying compensation through slaughtering a sheep or some other poor innocent animal. If you go back far enough in your Scottish history, you will find that restorative justice was there before. Another way of doing it is in the modern time, asking yourself, why is it in civil justice systems we don't need the state to resolve disputes? It's between individuals. That's how the civil justice system works. But in the criminal justice system, we need the state. So the restorative justice process kind of takes the state temporarily out of that interaction between the offender and the victim and other people connected to them, and tries to use that very encounter as a means of changing the way people think about their behavior and think about how to make things right and how to carry on going forward to avoid those things from happening again in the future. So I think that there are good examples in your history and in current contemporary civil justice systems that show people that actually we do know about restorative justice. We do. We understand it. It's often how we resolve disputes if we don't go to the criminal justice system. What people are unused to is the idea that this could be another way of doing justice that is formally recognized. But I think if it's always going to be parallel to your criminal justice system, somehow linked to your criminal justice system. If there's a reneging on the restorative justice agreement, it will probably have a pathway back into the criminal justice system. So, I think you can set some of those concerns to rest by showing that it's not abandoning the mainstream system. It's simply providing another avenue, another pathway that's very meaningful, that helps people, that seems to particularly provide good victim satisfaction, which isn't all, and may also contribute more to safety. One of my favorite stories that isn't original, I got it from someone else, but I love it, is if you were driving a car that you thought might break down, and you had two routes home. One route you were going to go through, but both streets have a lot of offenders, former offenders living on them. One street have a lot of people who went through the formal criminal justice system and prison, and the other street, people who went through restorative justice programs. Which of those avenues would you drive your car down? We all know what's safer there. It's a great example, isn't it?
Great example. Yeah. Anne, thank you so much. It's obvious from what's coming up in the chat that we could keep you all day. I found, and I think I speak for everybody, I found your presentation